There was a decision published there last week from the UK Employment Tribunal. The UK Employment Tribunal is similar to the WRC or the Labour Court here. It deals with employment disputes. This particular case was kind of unique insofar as it was the first time it's thought that an employee in the UK was fired for failing to wear a COVID-19 mask, a mask to deal with the COVID-19 pandemic. The background to the case is the driver in question was a Polish gentleman called Mr. Kubilius, who was a bulk liquid lorry driver. He, in the course of his employment, went to a client site. I think the client site was owned by Tate & Lyle, a very large UK company. They had policies and procedures in place where employees and indeed any visitors to the particular site in question were to wear masks, COVID-19 masks. Now, the driver refused to wear the mask, and on the basis that he wasn't getting out of his cab and that it wasn't the law in any event, it was only a rule or regulation in that particular workplace, and there was no legal obligation on him. That was his position. So Tate & Lyle then wrote to his employer and basically said, we want this man's name because we want to add him to a list of banned lorry drivers to the site. His employer then brought a disciplinary process or proceeding against him, and during this proceeding the employer put the allegation to him that he was failing to follow reasonable direction, he was failing to follow health and safety rules and procedures in the client site, and was basically causing a difficulty for his employer. The driver's position was that it wasn't legal or a legal obligation, it wasn't the law that he must wear the mask in the workplace. He was unrepentant, he was unapologetic. The employer then took the view that this was likely to occur again at other sites if this gentleman was sent out driving his truck on behalf of his employer, and they decided then on the basis of trust and confidence that they could no longer have trust and confidence in him, and they ultimately dismissed him. They summarily dismissed him on grounds of gross misconduct in June 2020. He brought a claim then to the Employment Tribunal in the United Kingdom. This is the equivalent of the WRC and the Labour Court here, and the Employment Tribunal basically said that the driver's refusal to wear a mask constituted misconduct. The driver's employer afforded him a fair disciplinary procedure and gave him the opportunity to appeal the decision. The employer had acted reasonably, according to the Employment Tribunal, and the insistence of the driver that he had done nothing wrong had naturally led to a loss of trust and confidence by the employer about future conduct in similar circumstances. The Employment Tribunal therefore dismissed his claim, dismissed his case, he lost it, and held that the dismissal was lawful. Now, they operate a similar sort of a principle as is operated here in the WRC and in the Labour Court, and that is that the tribunal or decision-making body will not substitute their judgment for that of the employer. What they will do is they look at the decision of the employer and see whether that decision falls within a range of reasonable responses in the particular circumstances. And in this case, the Employment Tribunal held that yes, the decision to terminate was within the range of reasonable responses. The case is Kubilius versus Kent Food. Kubilius versus Kent Food. Mr. Kubilius is a Polish national and a bulk liquid lorry driver. Interesting case. It's thought to be the first case in the UK where an employee has lost his job or her job as a consequence of failing to wear a mask in the workplace in respect of the COVID-19 rules and regulations and laws and so on. And even though it's a UK case, it is likely to have some influence here when similar cases are bound to come before the WRC or the Labour Court or some other court or some other forum here in Ireland. So it is a useful case to have a look at. You can read the full decision if you wish on my website employmentrightsireland.com. have a look at the blog post. It's Kubilius versus Kent Food, and the full decision is on my website in that particular blog post. If you find this video useful, I'd appreciate if you gave it the thumbs up down below. Thanks for watching.